very much. Thank you very much, Calvin. Thank you very much, Ian, for all the work you put into organizing this for us. I'd like to also thank the University of Houston Law Center and the University of Houston's chapter of the AIPN. I want to also thank all of you for being here with us today. I know this is a busy time of the semester, and I appreciate you taking the time to be here today. So basically, I'd like to talk about one of my favorite subjects, which is drafting. And you see this little guy and this character here, and I was thinking, I wonder if they think that's supposed to be me. Well, actually, no. That's supposed to be a potentially irate client or a potentially irate judge or arbitrator who can't make sense out of a contract that maybe you've written. So what I'd really like to do is try to help you to avoid having that situation, and instead of that, putting a smile on a person's face like that because of clear drafting. So I've called this Draft for Success, and of course you've probably heard of the book called Dress for Success, and I guess it could be debatable which is more important. I can't help you much with dressing for success, but I can help you hopefully with drafting for success. And I like to think in the long run, drafting for success is more important than dressing for success. Just going to cover 3 topics today. One will be the role of the contract drafter, one will be drafting techniques, and the other will be effective editing. So first of all, I'd like to talk about the role of the document drafter and the drafting process itself. Now, the drafter of documents is very important. Many people think of drafting as a boring and a routine part of business. But I'd say au contraire. I'd say it's a vital part of business and can be actually very challenging and rewarding. Many times in my work, I have to admit that I get a great amount of satisfaction out of taking something, perhaps a preceding document that's quite unclear, and making it very clear, or creating something from scratch, as it were. And I would also say that the world's best negotiator is useless if what she negotiates, for instance, does not get properly reflected in writing. So you can have the greatest negotiator in the world, but if there's no drafter to put those ideas into very understandable language, what's the use? Now think of some documents that really made a difference in history. Code of Hammurabi, Lex Romana, U.S. Constitution, etc., etc. And I imagine that the people who were writing these documents didn't necessarily know how long they would last and how important they would be. Just like the lawyers of my previous company, BP, who wrote the drilling contracts, for instance, for the Macondo well, the famous spill that became such a problem for the industry. Those lawyers probably woke up one morning and say, oh, here's another drilling contract, let's pull this form off the shelf and let's just change it a little bit, never imagining for a minute that eventually their words and their phrases would be analyzed by literally hundreds of lawyers, and that a single comma would make a big difference as to whether or not BP was able to avail itself of $750 million worth of insurance that Transocean had. So never underestimate the importance of what you're doing. Contract drafters, we can also call them transactional lawyers, I would say play as important of a role as the negotiator, the supplier of goods and services, or the marketer. And the mark of a successful transactional lawyer is one whose contracts seldom need interpretation. So basically, that's how you know if you're doing a good job, that people aren't constantly coming to say, what did you mean by that? Those are words we don't want to hear from our clients. It should be crystal clear. That's a big function we play. And in that same regard, the transactional lawyer can play a huge role with regard to reducing and minimizing the amount of litigation that's necessary. If all contracts were written well, then most disputes would be only about contract breach and not about what do the words mean. So much litigation can be avoided if we just write well to start with. Talk a little bit about drafting techniques. And I'd like to talk about what I call the 5 commandments of contract drafting, which is to understand the client's objectives and to understand the subject matter itself. We have a tendency to always want to get to work right away and get the job done quickly, but we really have to know the context. We also need to write clearly and unambiguously. We should be consistent in our style, our terminology, and our definitions. We also need, as lawyers, to know and properly reflect applicable law. You can be the greatest drafter in the world, but if you don't know about applicable law, then your contract could possibly be unenforceable, no matter how well written they may be. And then also create contracts that achieve your side's objectives fairly. And we'll talk about that, actually each of these in a minute. So let's first talk about understanding the subject matter and the client's objectives. Effective drafting involves more than wordsmithing. It's also communication towards consensus is the key. The effective lawyer must become conversant in various industries and technologies. One of the fun things about becoming an in-house lawyer, for instance, is that you're part of the team and you can really get to understand how wells are drilled and how seismic is taken and that kind of stuff. So always make sure you take the time to understand the context you're working in. And if you're not sure about something, about a technical aspect of something you're working about, ask your client. Many of them will love to explain to you about how all this works. And if you don't have someone convenient like that, it's a lot easier nowadays than it was when I started in terms of getting the information you need. Just go to the internet and do some research. Then finally, make sure you understand your client's priorities and their bottom line requirements to focus on what's essential. It could be that you think something in this contract is really important, you're focusing on like crazy, but that's not really necessarily what's most important to the negotiator you're working with as well. So have a good discussion with your negotiator and the team and understand where the real main objectives are. So you need to have clear and unambiguous writing. So we just use that famous KISS terminology, keep it simple, stupid. Documents need to be clear, simple, and concise. And we'll talk about each of those words and what that means with regard to drafting. Very importantly, if you take away nothing else today, you need to write to express and not to impress. People know you're lawyers, okay? They don't need for you to show that to them by a lot of long-winded paragraphs, a lot of difficult things to read. So it's very important that you're trying to express, and we'll talk a bit about what I mean by that in a minute. And then finally, documents don't need to be eloquent. We're not after a Nobel Prize in Literature. By the way, congratulations to Bob Dylan, who just won that was a great selection, the most recent Nobel Prize in Literature. Then in terms of clarity, simplicity, and concision, clarity is that above all, the parties to a contract should understand what they're agreeing to. Other audiences must be able to understand, especially judges, juries, and arbitrators. So you're not just writing for the people at the table who should know what all this is about. You're writing for people down the line who need to actually enforce this contract, work with this contract. Documents must be simple, no special effects, and every word should perform its function, no less, no more. And we'll talk about that. You see some examples I'll show you about how we have really long-winded paragraphs that are really hard to understand, especially if you're not a lawyer, okay, and how you could write those more concisely. And finally, concision just relates to saying what needs to be said in the fewest words possible. So those are some principles I'd like you to remember. Now, clarity. Let's take nothing for granted. We've all heard this expression, all that glitters is not gold. Can anybody tell me why that expression really is not well written? What can that be interpreted to mean? That can actually be interpreted...
Gold doesn't glitter.
What's that?
It could mean gold doesn't.
Yeah, exactly. It can mean that gold does not glitter. Think about it. Everything that glitters is not gold. Okay, so in essence, I can look at those words and say that gold doesn't glitter. So what could we say instead? Well, we could say, not all that glitters is gold. That's what should really be said. So let's not just always accept as correct things you see in a model form contract, for instance. Let's look at words. That's fine as an expression, I guess, because everybody knows what that's supposed to mean. But in a contract, I guarantee you, I could argue and probably win that that means that gold does not glitter. So we talked about express versus impress. Who can tell me who these two gentlemen are? Hemingway, and the other? James Joyce. Got some English majors in here. Great. Okay, so they're my prime example of what I mean by express versus impress. So let's start with Hemingway. Okay, first sentence of For Whom the Bell Tolls. He lay flat on the brown, pine-needled floor of the forest, his chin on his folded arms, and high overhead the wind blew in tops of the pine trees. Beautiful image. We know exactly what he means. Now let's go to James Joyce. First sentence of Finnegan's Wake. River run past Eve and Adams, from swerve of shore to bend of bay, brings us by a commodious vicus of recirculation back to Howth, Castle, and environs. I have no idea what that means, and I certainly don't want to read on. I guarantee you. So I'll take Hemingway any day, and that's how I'd like you to write, to express and not to impress. Obviously, Joyce impressed a whole bunch of people, not me because I never got through any of his books, okay? But basically, think about that. Now, we're going to go to simplicity now, the KISS principle, and I swear, this is a sentence that I or my company paid for from a very high-priced law firm, and I couldn't believe it. Look at that. It's all one long sentences. And you guys as lawyers, sure, you can go through there and after 5 or 10 minutes, figure out what does that mean. Think of your poor clients who are like engineers and geologists and financial people. They have to read this kind of garbage? No way. So why don't we just keep this simple and you'll get these slides and go back and see if really anything is missing here. Why not just say, the parties will discuss the effect of any force majeure on the project. A party whose project chargeable costs or performance are negatively impacted by force majeure will be entitled to commensurate additional time to perform and recovery of such costs. Okay, that's kind of people talk. It's in 2 sentences, and you can understand immediately what that means. The content is basically the same. One is the kind of thing that people hate about the way lawyers write. The second is what would put a smile on the face of your clients, I guarantee you. Okay, now, sentence diagrams. I'm not going to teach you about sentence diagrams, but by the way, that looks like my 4th grade teacher, Sister Ann Fidelis. And I used to always wonder why she insisted that we diagram sentences. We had to do this when I was in school, basically. And I finally discovered why. And that's that if you can't write a sentence simple enough to diagram it, then you should probably start again and break it down in some more sentences that you can write coherently. So this is the 4th Amendment to the U.S. Constitution as a diagram sentence. So you can see that's pretty awful, right? I'm not criticizing the 4th Amendment. It's a wonderful set of words in its own context, and they were trying to be vague for obvious reasons that all of you know. Those are the words without being diagrammed. And I, as a contracts lawyer, if I had to write those same words, okay, this is what I would say. I will not win a Nobel Prize for literature, but I'll make my clients happy. So, the government shall not unreasonably search or seize persons or their property. All warrants must be 1, based on probable cause, 2, supported by oath, and 3, reasonably detailed. So again, that's how I'd write that if I had to write that in a contextual context. Concision. Choose your words carefully. Words are beautiful. Every word has its place and its reason. But the idea is not to use a whole bunch of words you don't need. Go through and pick the prettiest ones and make a beautiful necklace out of it. That's what we're trying to do. That's what we mean by concision. Now, are the AIPN form contracts, for instance, concise? I'd say no. They're not bad, but they're written by committee, so therefore they can actually be written more concisely. Let's look at this article. Contractor shall be responsible for the safekeeping of seismic data while such seismic data are in the custody of contractor and until such time as the contractor delivers to them company representative or to a third party designated by company. Whew, it's a lot of words, right? Okay, can't we just say contractor shall safely keep seismic data until delivered to company representative or third party designated by company? Isn't that the way we think? Isn't that what we talk to each other that way? Why can't we write that way in contracts? Write short sentences. I would say that most sentences shouldn't be more than 25 words. Not an ironclad rule, but I would say this. I like to use what I call the one breath rule, that if you can't say a sentence in one breath, put a period someplace and start again. So basically, here's an example. Buyer who will make all shipments and arrangements will accept the goods at delivery, place of delivery, which is seller's plant in Soyo, and will have the goods removed by no later than 10 days following the date of this contract. Okay, a lot of words. Why not just say, within 10 days of the effective date, buyer must accept and remove the goods from seller's plant in Soyo. Much simpler, we all understand what that means. Soyo, by the way, is a city in Angola. I've underlined the words will and must because it's something you should think about. I don't have time, unfortunately, today to talk about this in detail, but my preference is when I have a true obligation to use the word must, because must is always an obligatory word. Shall sounds obligatory, but can have a future sense as well. So I'm not saying you use must all the time, because there are definitely future situations that are not obligations. But think about using the word must more than you ever have before. It really works better, I think. And so all the things I've said about normal contracts are even more important in the international context, and in terms of the simplicity and conciseness of language, because why? People are from different countries, they're from different cultures, they're accustomed to different legal systems, and finally, they speak different languages. So when you're in a situation where you have two or more nationalities trying to hash out a document, the more simply you can write, and also talk, by the way, and not using slang and making sure you pronounce well and all those good things, is also true in drafting. So for those reasons, even more than a domestic sentence, circumstance, we really need to make sure that we're writing concisely. Just a few words on style. I'd say use ordinary words to the extent possible. And we'll talk about each of these, by the way. Avoid the passive voice. If anyone here speaks a Romance language, for instance, natively, they'll know this is hard to do because the passive voice is used a lot in Romance languages. Write positively, not negatively. Lawyers love to talk and write negatively. And I'll show you what I mean by that. Pick the best word. Don't say more words than you need to. I'll show you what we mean by that as well. And then define carefully. Very important. Here we have use ordinary words. Contract drafters have a tendency to just throw all kind of words when they're not necessary. So, for instance, they'll say an adequate number of instead of sufficient, or in the capacity of, as, or until such time as, until. My absolute favorite, or the one I really hate, I should say, is in the event that. That means if, nothing more, nothing less. So think about the wonderful songs in history that would have been completely ruined had we used the words in the event that. Think of Dionne Warwick, for instance. Dionne Warwick singing, "If you see me walking down the street and I start to cry each time we meet." Now think about, she says, in the event that we see me walking down the street. Doesn't that just ruin the whole thing? Or pretend you're at Camelot, right? And here's Lancelot trying to seduce Guinevere in her boudoir. And so instead of saying, "If ever I should leave you, it wouldn't be in summer," he says, "In the event that I should ever leave you." I mean, she'd probably kick him out of the room, right? So basically, always use if. There's no reason to ever say in the event that, unless you're trying to sound like a lawyer, which I say is not your objective. Now, here's the example of the AIPN using the model, the passive voice quite a bit. I'm not going to read all of that because we are a bit limited on time today, but I am going to go ahead and show, you can see what it says and just see how it can be said more simply. Unless this agreement says otherwise, operators shall charge joint operations costs and credits to the joint account. The parties will share these costs and credits according to their participating interests. So see how simple that is and how nice that sounds? That's all you really need to say. Okay. Draft positively. Affirmative sentences are clearer than negative sentences. That's how we actually speak to one another. Lawyers have a tendency sometimes to actually speak negatively as well. Negative sentences require the readers to first comprehend words and then negate them. So it's a whole thought process that has to be done in order to understand a negative sentence. And then sentences with more than one negative are even harder to understand. Then finally, negative sentences are longer than affirmative ones and thus less concise. Remember we said we're trying to use as few words as possible? Well, one way is to make sure we speak affirmatively. Now, lawyers tend to write negatively. I think a doctor would say, take this pill if you feel nauseous, as opposed to don't take this pill unless you feel nauseous. See the difference there? Means the same thing. One is easy to understand and the other is not. A couple of examples. Negative. This section does not apply to deliveries made after June 10th. Positive. This section applies only to deliveries made before June 10th. Even more important, and I got this actually from, I think it's a Mexican regulation. An application for a petroleum license does not become void unless the applicant's failure to provide requested information is unreasonable under the circumstances. Say that positively, it's much simpler. An application for a petroleum license remains valid if the applicant provides the requested information within a reasonable time. Much simpler, right? That's what we're trying to get at. Choose the best word. Another thing that lawyers like to do is say things like covenant, promise, and agree. It might be that in real property law there might be some reasons to do that, but I guarantee you that in basic oil and gas transactions, usually it's best policy just to pick the best word and stick with it instead of using all these words. And it just makes your contracts, all these things have a cumulative effect to make your contracts nice and concise as opposed to being overly verbose, for instance. Use simple verbs. Instead of saying make a proposal, just say propose. Instead of saying state a grievance, just say protest. So again, it may not be quite as flamboyant, but it truly is going to make your language much more concise. To define, fine is define. What I would say about that is definitions are very important in contracts, and they can really make or break contracts in terms of being cohesive and usable documents. Crisp and complete definitions are key to superb contracts. Okay? If you use a specific term in a contract, especially more than once, make sure you have a definition for it. I mean, things like event of default or confidential information. Never insert obligations within a definition. This is so important. You always see this, you see this very often, that people will define force majeure, and then within the definition of force majeure, they'll talk about how many days a party has to do something. That's wrong for several reasons. It destroys the definition, which is supposed to just tell you what a word or term means. And also, people may forget to look there. You want to know your obligations under force majeure, you're probably going to look at the clause and not think to look at the definition for obligations. So remember that. You can either have definitions created within the text of a contract or separately, but I suggest you don't do both. Typically, a short document, maybe 5 pages or less, you can just put parentheses behind a word or expression, and that's fine. But once you start having a document that's longer, or especially if you start having more than 10 or 15 definitions, I suggest you go ahead and have a separate list of definitions. And one thing I like to do is to put my definitions in Appendix 1, for instance, at the end of the contract, or rather than beginning. I like to think of my contract as something a person's going to read, and the last thing I want my reader to do is think that that person needs to go through that entire list of definitions before reading the contract. Not necessary. We can understand contracts just fine without understanding the definitions. We go back to definitions in cases of any doubts. Some pet peeves I have. One of them is saying, for the avoidance of doubt, right in the middle of a contract. To me, that's kind of a weakness. If there's any doubt in your drafting or in the content, My rule is to go back and find where the doubt is and make it so there's no doubt. So please, I would suggest you avoid saying for the avoidance of doubt. That versus which, I wish I had time to go through this a little bit more detail. The easiest way to think about it is just to use that whenever it sounds good. Because what happens with lawyers and contracts, we have a tendency to use which all the time instead of that. And to me, it just sounds overly legalistic and is really not correct. But you could go online and find all the fancy rules. That's my favorite way to think about it. And who versus whom. Unfortunately, the word whom is disappearing from the English language, but I guarantee you, if you're in a negotiation and you can use that word whom really strongly, I think you can impress the other side and speak with authority. So don't forget whom, and it just basically substitutes for a word that's serving as an object. Again, don't have time right now to go through all of that. Just think about Ernest Hemingway, For Whom the Bell Tolls. What if he had called his novel Who the Bell Tolls For? It doesn't sound very good, does it? It doesn't sound very erudite at all. So try to avoid legalese and foreign phrases as much as possible. I'm not saying you could never use them. Mutatis mutandis is fine in the right context to use that, but don't spill them all over the place just because you're, again, trying to impress somebody. Okay? Redundant numbering. A lot of time is spent in contracts to write out the number and then write the whole thing out, okay, in parentheses. My theory is forget that. Make sure you get the number right the first time and write it just numerically. If you need to, if you're afraid of that, highlight your first draft, all of your numbers, and go back and make sure they're correct. But people go through all this trouble, and it's even worse in other languages to do this. And so a tremendous amount of time is spent on doing this and doing it. And again, sometimes people forget, so I don't like to do that at all. Obviously, your contract drafter needs to know the law. You need to have more than just good drafting skills. The transactional lawyer must make sure that the contract is enforceable under applicable law and not violative of any statutes. Obviously, the best worded contract in the world is not worth the paper it's written on, if it can't be enforced. And obviously, if you're dealing with all different kinds of jurisdictions, as I have during my career, there are times when you need to spend a little bit more of your client's money and get an opinion from a local counsel to make sure that the primary provisions of your contract will be enforceable under the applicable law. And then play fair. What do I mean by that? You need to create documents that are fair to both sides. A lot of people think their job is to write this contract that's as tricky and as one-sided as possible. Well, that's just a waste of time because most of the people you're dealing with are not idiots. They're smart people, and they can be offended, or they can think that you're not playing fairly. So just play fairly. And I like to start my contracts fairly. In other words, I'm not trying to go from here, this other person's over here, and it takes forever to get here, and a lot of acrimony on the way. I like to kind of start closer. Sure, I'm going to favor my client to some extent. I'm not going to try to pull any fast tricks. The last thing you want to do, and so that we're arguing about what's really important. So try to remember that. Another thing that's kind of annoying, people send you documents as a PDF instead of a Word document, like you're just going to say, oh yeah, I'll accept that, no changes needed. Forget that. I mean, so just be courteous as far as that's concerned, so they don't have to either make up what will be a somewhat erroneous Word document of a PDF. Just go ahead and send that to them. Don't always insist on doing the drafting. If you know that the lawyer on the other side is a good drafter, let him do all the work, all right? So just don't have to always do the drafting yourself. On the other hand, if you're not sure or you know for sure that the other side will create a bad document, then yeah, you might want to politely insist on drafting the document. And don't claim that a document is a model contract if you've made all kind of changes to it. Again, that's just something that annoys people. You say, oh, this is the model contract. And then you do a red line against it, 80% has changed. So that's not a fair thing to do either. So then a summary with regard to drafting is to, again, be clear and concise. I can't say enough in terms of how that saves you time in drafting and in negotiating especially, and in editing, which we'll talk about in a minute. Express, don't impress. I think I said enough about that, but that's something I really want you to remember. Okay? Avoid the passive voice. Try to just write subject, predicate, object as much as possible. And then you want to simplify your language. Again, instead of saying make a proposal, just say propose. That doesn't sound like a lot in one small context, but again, the cumulative effect can be quite a bit. And then write to an audience not familiar with the deal. If you're ever in a negotiation and your cohorts from your company are saying, oh, come on, Norm, we know what this means. Say, of course you know what this means. You're negotiating this deal. I'm not writing it for you. I'm writing it for the people who are going to have to use this contract and for the judge or the arbitrator that needs to interpret it someday. So again, that's your audience. Quickly, we're going to go through contract editing because sometimes the analysis stops at drafting, but editing is also very important. And I like to say there's two ways to think about editing. One is just to draft your document right the first time, okay? And the other is just kind of just do it and then fix it later. And neither of these approaches is necessarily correct, and you've got to do what's most comfortable to you, and the more experience you have in writing and knowing where you're headed on these kinds of documents, the more likely it is you'll start using that first approach. So in terms of getting it right the first time, there are some disadvantages. For instance, a distraction-free environment is crucial, which is really hard to find nowadays with all the emails coming in and everything else. And also, really only works well for an experienced contract drafter, almost like on autopilot, knowing how he or she wants to structure these contracts. In essence, it's kind of a self-editing and questioning as you go along, as opposed to at a later date. And in any case, don't ever think that you can write things once and then not look at it again. I don't think anybody is that good, to tell you the truth. And then so, in terms of the pros of that approach, it's more efficient if you can do it, and it also protects against some other thing taking or getting in the way later on. If you've allocated some time and you're writing well the first time, then you're done, as opposed to the other thing about just do it, and with the idea that in 3 days from now you'll go back and edit it. Well, maybe 3 days from now you'll have something else that's even more important. But it's highly intensive, and it needs the conducive environment, like I said, and you might even lose certain concepts. If you're writing right the first time, basically you may be focusing too much on how you say it and not enough conceptually. On the flip side, just do it. Creative writers are often encouraged to use this approach. I think it's probably appropriate for less experienced drafters as well. The idea is just to relax, get the ideas out, don't worry about the product, but don't be like James Joyce with some kind of stream of consciousness either. Okay? The pros to that, it does not need a pristine environment. It's easier to think aloud and get started than if you're trying to concentrate so much on writing correctly. And then the con is that the light at the end of the tunnel is distant, because after you finish that first draft, then you still have the process of going back and extensively rewriting what you yourself have done. Self-editing, very important, very difficult to learn. We always think we write well, and we don't see our own mistakes, unfortunately. That's why it's always good, if you can, to get someone to look at your work. Try to read your work impartially and questioning, not always easy to do. Make sure your contract is balanced and fair. One of the things going through your mind is fairness when you're looking at your own writing. How will the other side take this? This reduces negotiation time and creates trust, to the extent that you can be writing fairly and get the trust of the other side. It truly does facilitate negotiations. I've seen it many times. And it's better to edit well yourself than to force your boss or the other side or your client to do that. So it's a hard skill to have. Now, editing others. You have an absolute right to a balanced document, even if it means giving the other side a sea of red ink. I mean, since the other side has said they're going to be the drafter, if they give you garbage, you have every right to go back and write and edit it extensively. However, if you're using an agreed model contract, then obviously you have to be a bit more judicious in the changes you make. I'm not saying, for instance, those clauses you saw in the AIPN model that you necessarily go back and rewrite those, because that's a tremendous amount of work, and it also kind of denigrates the fact that those are a model. However, if there's something in a model contract that's really going to be adverse to you or could cause confusion, by all means, you need to edit that. One approach you can do in basically editing others' work is to go through and first identify what are really key issues and let the other side know that. Say, I decided to go ahead and show you what I think are the principal problems we have in this contract. I'll take another pass later on to give you the finer points. That'll kind of help in order, number one, not give them a sea of red ink on the entire document, and number two, to truly focus up front what's the most important. Maybe you'll be able to go back and do a fine tune at the end, almost unilaterally, and hope that you get their acceptance on just the writing aspect of it. If a document is unworkable, if it's so bad that it doesn't work, find a diplomatic way to say that and offer to rewrite it. I've had to do this, I've had to do that even with the National Oil Company in the past, and it can be done, and sometimes it really has to be done. Now, I'll take with a grain of salt what I've said, because if you're in a situation with a party that really has the upper hand, very often a government, for instance, in a contract negotiation has the upper hand, and or another party who really has something you want, then you may want to be a little bit more judicious about how much red ink you create. Having said that, your responsibility is to make sure that your client's interests are protected. So there's kind of a balancing that goes on with all this. Just in terms of the process, this is kind of what it looks like. I'm sure you're all familiar with this, but you take what could be a pretty simple concept, but said with too many words. In the event of any suspension, company and contractor shall meet at no more than 7-day intervals with a view to agreeing a mutually acceptable course of action during suspension. What you do, of course, is go back and you use track changes, and you come up with the same concept said much more succinctly. During any suspension, the parties shall meet at least weekly to agree actions. Everybody knows what that means. Why do we have to say it that first way? I don't understand. Okay. So the main objectives in terms of editing are to create readable, organized, logical, and clear documents. We want to simplify our language. We want to make sure that we're using terminology consistently throughout. Make sure we're not using a word like force majeure in different ways and throughout the contract. We want to reduce negotiating time through good drafting. Really, a negotiation, if you have good contracts to start with, you're really talking about the commercial points and the technical points that need to be discussed. Instead of having 6 people from each side in a room, a lot of them technical people, with the lawyers arguing about, semicolons and all this kind of stuff because someone didn't write well to start with. So negotiations can be reduced so dramatically with good drafting. It's miraculous, actually. And make sure the other side understands the reason for proposed changes. So let's say, for instance, that you're doing a red line copy of a contract for the other side. Use that little comments function and explain your changes. Why? Because that means rather than having to go through every single point, every change you've made in the contract in a negotiation, they're going to have seen your rationale, and if you have valid points, they will agree with 80% of those. So you're only arguing about 20%. So negotiations are a long process, and to the extent you can help resolve issues before you ever are face to face, it's wonderful. Just a few words to the wise as we're wrapping up here. In terms of in-house counsel, don't make your boss have to do this kind of editing or cause your colleagues to struggle, understand, or have read it twice. Outside counsel, now your clients have paid you good money to avoid writing the first draft. Don't make them waste time redoing what they've paid for. This has happened to me many times in my career as an in-house counsel. I've had to actually ask for different lawyers because I couldn't deal with the documents I was being given. I literally cannot afford to spend all of my time redoing something that's not been done right the first time. And then clients, obviously, you need to demand precise drafting from your attorneys. So every client has the right to say, you know, can't you make this simpler? And I guarantee you, I've never had a client say, hey Norm, can't you throw in a few more Latin phrases here? Can't you make this sentence like a whole paragraph instead of like 3 different sentences? I guarantee you, I've never had anybody say anything remotely like that. It's always the opposite. Okay? Summary in terms of editing, again, determining your general approach. It may depend upon the circumstances. Self-editing and editing others are quite different. Effective editing, just like good drafting, can increase trust and reduce negotiating time. There are many computer-based techniques that exist that you can use. I mentioned obviously redlining and of course you want to use your spell checking. You may or may not want to use grammar check because it's not always right. And then in terms of comments and everything else, using footnotes is a good way, especially in drafts. So just use those techniques. And remember that most documents will need editing. So in terms of summary of what we said today, efficient and effective contract drafting techniques are an essential element of the transactional lawyer's toolkit. Very important skills you have to have. Again, right to express, not to impress. The commercial clients want clarity and concision more than eloquence. If you're a frustrated creative writer, don't bring that to the contract drafting table, please. Write simply and concisely. The objective is to make your contracts readily understandable by the eventual users and interpreters. So again, that's your target audience, people way down the road, maybe 25, 30, 35 years from now. You'd be surprised how long oil and gas contracts last. Crisp drafting leads to crisp negotiations. I've said that before, and I've seen it time and time again, that the best thing you can do for your team, for both sides, is to make sure that document is good to start with. And finally, take pride in your drafting because you never know where your contract will turn up, especially in a court, for instance, and you want to make sure that it reflects well on you. You should almost have a style that you could see 10 contracts and you know that's yours without even seeing what it was because the way it's set out, the way that the kind of language you use. So that's basically all I had to say today. I want to thank you for being here, and if there are any questions, I know you may be needing to go to class, and those who do, please feel free to go ahead and do so, but I'm more than willing to take on any questions you might have. Okay.
So